Kouri Richins. We have a lot to talk about. Yes, we do. We have a lot of legal going on. There's a lot that we have not caught up on. And I said, we'll go back. We'll look at some of the civil stuff. Oh boy. Oh boy, is there a lot to look at that we have not looked at. So it's Thursday, it's April 2nd. We're going to be looking at all of the new legal woes facing Kouri Richins. She has a new court date in addition to her sentencing date in the other criminal case. Remember that one? Yeah, the fraud case. New legal date for that. Updates, some legal troubles. By some, I mean lots. So when we're talking about the civil suits, what do we have? There's a business lawsuit. We're not getting into that one today. There's some tax stuff. We're not getting into those today. Kouri sued the estate. The estate sued Kouri and others. The estate has its own probate. It's going to be a day, everybody. Buckle up. All of the cases I just listed, the civil cases, the estate cases, Kouri's lawyer withdrew on every single one. Notice of withdrawal of counsel comes now Randall Jeffs and Ryan Morley of the law firm Jeffs & Jeffs, pursuant to rule in Utah, hereby withdraws as counsel for Kouri Richins and K. Richins Realty. There are no pending motions in this matter. No hearing or trial is currently set. What day did all of her lawyers yeet? Well, that would be March 17th, chat. That would be March 17th. When did the verdict come in, chat? Oh, March 16th. The day after the verdict, all of the civil cases, her lawyers noped out, just whoop, dip. We are going to cover a ruling from Judge M in the Kouri Richins sues the estate case. Let's take a look real quick at the complaint. This was Kouri suing Katie in her capacity as PR of the estate. Eric and Kouri each contributed their own separate funds to the down payment before occupying the family home, and in accordance with the agreement between Kouri and Eric, Kouri put the gas, telephone, internet, and electric utility bills all in her name. Eric was not listed on the utilities. This does nothing for me. This is not uncommon if one person's paying the mortgage and the other person is paying all the utilities. Whatevs. From September 2013 until Eric's death, March 4th, 2022, all mortgage payments on the loan have been made from Eric and Kouri's joint account. Do we see what she's trying to argue? That this is not Eric's separate property? Since Eric's death until her arrest, Kouri paid virtually all expenses related to the home, and neither Katie nor the estate has provided material contribution. Do we see why this was some of what they were arguing about at trial? Who paid? They say the family home constitutes marital property. Kouri's entitled to half of all equity in the family home. Alternatively, if she is not entitled to half of all equity, she is at least entitled to half of the increase in equity value that occurred during the marriage. So this is what Kouri sues the estate is largely about. I'm entitled to money from the home. So Kouri versus the estate has been going on since this filing in 2023, has over 680 docketed items. In that time, there has been some fighting over whether or not the case will get stayed. Kouri asked that all these cases get put on pause, get stayed, pause, time out, until the criminal case was done. And the court did not grant those in the entirety. The court said, okay, you can't depose Kouri until after her criminal trial, because the deposition of Kouri, what's the deposition of Kouri going to be? Girl, you killed Eric. You have no entitlement to any of this money because you killed him. That's what the deposition is going to be, right? So with that, we are looking at cases where there's going to be motions to terminate these cases because she was convicted. But of course, if she had to sit for a deposition prior to the criminal trial, then you would have an issue where Kouri's like, I have a Fifth Amendment right. So we have this issue where Kouri wanted the deposition stayed and the court stayed that, but the court's like, other discovery can still keep going. There was discovery ongoing, but not all the discovery was ongoing. But in that, there were some issues. And we're going to look at the first of numerous rulings of Judge M. Why, Emily? Why are we doing this? Purely for schadenfreude. Purely for the joy of being like, take the L. Our first order of business is an order on a motion for terminating sanctions. In Judge M, I trust to give us a background. So are we going to go through all of the legal ins and outs of this? No, we're not. But we are going to go through what the court said. This was filed May 14th, 2025. This matter came before the court on March 26, 2025 for oral argument on defendant Katie. And we're just going to go with Katie. At the very beginning of all of these cases, the court and counsel all indicated that they were going to call the parties by first name because everyone had Richins connected to their last name and it got very confusing. So the court decided everyone, and the lawyers agreed that everyone was just going to go by first name, and everyone's agreed to that. So you're going to see everyone going by first name because of this. Katie's motion for terminating sanctions. This oral argument was not televised. It was just the lawyers that were there. The parties were not there. It is civil. We didn't see it. So Katie's lawyers were there. Kouri's lawyers were there. Having considered the briefs, the oral argument, the case law, the court hereby orders as follows. 1, to the extent the motion requests an award for reasonable attorney's fees and costs that Katie incurred in 1, preparing for Kouri's deposition, 2, appearing for Kouri's noticed deposition, 3, briefing the issue of Kouri's failure to appear for deposition, including both this motion and Kouri's related motion to stay her deposition, the motion is granted. They didn't file the motion to delay Kouri's deposition until after all this went down. They were sitting there in a conference room or whatever, lawyer's office, waiting for the deposition, and Kouri no-showed. Katie is awarded her reasonable attorney's fees and costs incurred for the following: noticing Kouri's deposition, preparing for Kouri's deposition, appearing for Kouri's deposition, briefing the motion to stay, and arguing the motion and the motion to stay. To the extent the motion requests further sanctions, they did ask the court to yeet the entire case. The court said no. To the extent the motion requests further sanctions, it's denied without prejudice. If Kouri were to fail to appear for a deposition as noticed by Katie or ordered by the court in the future, the court could, in its discretion under Rule 37, impose additional sanction, including but not limited to striking Kouri's pleadings, eating the entire case, striking Kouri's claims, or striking Kouri's defenses. Consistent with Rule 73, within 14 days after entry of the order, Katie shall submit 1, a declaration of fees and costs she incurred. Don't worry, we're going over that next. And 2, a proposed order. Unless Kouri objects within 7 days after Katie files the declaration and proposed order, the court, quote, will enter an order for the amount claimed. Katie files the notice, and then in August, we get the order on attorney's fees and costs. We're going to take a look at that order now, because this is the underlying tension that's leading up to Katie going into trial to testify. Ruling and order on attorney's fees and costs. Before the court is defendant Katie's motion for attorney fees. And mind you, this is the estate. This is not Katie asking personally, through which defendant requests $70,350 in attorney's fees and $300 in costs, the filing fees, for a total of $70,650. Having considered defendant's declaration, plaintiff's objection, plaintiff being Kouri, and defendant's response, the court grants defendant's request for attorney's fees in part and denies in part. Let's see what in part means. The work performed in the time billed by defendant's counsel is reasonable with notable exceptions. Plaintiff asserts that the $70,000 in attorney's fees that defendant incurred are not recoverable as they are unreasonable, excessive, abusive, and not a reasonable fee for the legal services provided. Defendant argues that plaintiff, Kouri, failed to identify particularly problematic entries that are unreasonable, Defendant also argues that the trust case is materially different and requires far more time and attention than the other two cases, and that the deposition preparation and motion briefing were both complex and required a significant amount of time. Different cases, different problems. The court is persuaded by defendant's argument, defendant Katie. Indeed, it appears that defendant spent roughly 54.5 hours drafting the initial motion, with 42.7 hours attributed to this case, 7 to case ending 019, and 4.75 to case ending 230. The court finds the total amount of time drafting to be reasonable, and the allocation between the cases to be reasonable in light of the parties' claims. You can use it in other cases, it has to be modified, but the bulk of the work was done in this case. But the court finds other time entries to be excessive. First, plaintiff's counsel time entries related exclusively to conferencing about the motion, which amounted to 7.75 hours, are excessive. Second, plaintiff's counsel time entries on 2/10/2025 are excessive. There are 3 entries for that day from different attorneys. The last entry, the court says, is to draft reply in support of motion. The court finds these entries to be unreasonably duplicative and inefficient. You can't just run up your fees and charge them to someone else. So, Emily, what's the order? Here we go. Defendant Kouri Richins Benson for the estate is granted in part. The work performed is reasonable and recoverable, except for 7.75 hours related exclusively to conferencing about the motion. So the talk time, not it. Defendant is awarded $66,000 in attorney's fees and $300 in costs. Attorney's fees in the amount of $66,000 for no showing a deposition. So when is Kouri going to sue these lawyers? I don't know. But I imagine that at some point we're going to see Kouri turning around and suing the lawyers, saying that she was in custody during this period of time and they should have filed a motion objecting to her deposition. Because obviously. So I think we're going to see Kouri sue them. So in Kouri versus the estate, she owes over $66,000, $66,300 for no showing the depo. And they are 600, almost 700 docket items in, and she doesn't have a lawyer. This is her choosing to sue the estate. So when we look at the estate case, the most recent thing that happened in the estate case was 1, her attorneys yeeted out of the estate case. And 2, there's an order on a motion for sanctions. And we're going to have to take a look at that order on a motion for sanctions. This is the case that's probating the trust and the will. Oh boy, April 10th, 2025. This is, you can tell by the heading of the case, this is in the matter of the estate of Eric Richins. Order on motions for sanctions. Again, we're referring to the parties as Katie and Kouri. Katie is going to be the plaintiff in this circumstance. Kouri is going to be the respondent or the defendant in this circumstance. To the extent the motion requests an award of reasonable attorney's fees and costs that have incurred in preparing for Kouri's deposition, appearing for Kouri's deposition, briefing the issue of Kouri's failure to appear, and then the motions that came after it, because this happened in all 3 cases. They noticed Kouri's deposition for Kouri suing estate probate, estate suing Kouri. They noticed it in all 3. And so the bulk of the energy was in Kouri suing the estate. And so that's where we see that biggest award of sanctions. But there are sanctions in other cases. And that's what we're looking at now. Katie is awarded reasonable attorney's fees and costs for the following, same as the last suit. Noticing, preparing, appearing, and then briefing the fallout afterwards and arguing the fallout afterwards. So that was ordered. Counsel was there April 10th. So the question is, what's the order on attorney's fees? Order awarding attorney's fees and costs. On April 10th, the court granted Katie's motion for sanctions related to Kouri's failure to appear at deposition. This order is also May 14th. So all these orders came down the same day. The court orders Kouri to pay Katie $8,387.50, $66,300, and now $8,387.50. We got one more to go. This is the first amended complaint. So this is bringing other individuals into the estate. Katie is the representative, suing Kouri, Kouri's mom, Kouri's brother, Kouri's business. We've heard about the financial troubles, the accusations that Kouri is stealing from Eric, that Kouri Richins Realty is deeply in debt, that Kouri is taking money, the stuff that we heard about in the trial plus. They talk about the trust, which we saw. They talk about the stolen tax payments, which we saw in trial. Stolen retirement accounts. We heard about this in the bond hearing. We'll circle back to this more. On information and belief, at the time of his death, Eric had at least 2 retirement accounts on which the estate should have been the beneficiary. The grandmother account had approximately $40,000 at the time of Eric's death. The other account was a Utah Retirement Services account that was set up for Eric by his mother. Upon information and belief, the URS account had approximately $15,000. Upon information and belief, Kouri wrongfully and fraudulently obtained a payout from both retirement accounts after Eric's death. The total amount of retirement accounts was at least $55,000. That is money that is supposed to go to the trust. Just keep in mind, every time I say money is supposed to go to the trust, I want you to remember that the trust is set up to protect her and Eric's children. Other estate property. At the time of his death, Eric owned significant property that was his sole property. Such property included, but not limited to, at least $200,000 in cash believed to be in Eric's safe. Who got into the safe? $200,000 in cash. Is anybody totaling this up? This is in addition to the HELOC, in addition to the bank account, in addition to the credit cards, in addition to the taxes, in addition to the retirement accounts. And $200,000 believed to be in the safe. $25,000 cash on Eric's person at time of death. Contents of Eric's safe, theater room furniture, an electric motorcycle, a flatbed trailer, and other personal items. Eric owned and had title in several vehicles, ATVs, and other recreational vehicles. One of those vehicles was a 2019 Can-Am Defender Max with the VIN number listed. On October 24th, 2022, Kouri applied with the Utah Department of Motor Vehicles for a duplicate title on the Defender. In her application for duplicate title, Kouri made several false representations. Eric gifted her the Defender on October 24th, 2022. No appointment of personal representative has been granted or is pending. The value of the entire estate subject to administration, wherever located, excluding boats, motor vehicles, trailers, or semi-trailers, less liens and encumbrances, does not exceed $100,000. She is or was entitled to take receipt and ownership of the Defender. Those are what they are saying the misstatements are. Kouri purported to sign the application for duplicate title on Eric's behalf as his survivor. So Kouri is diminishing the assets going into the trust that was set up to benefit the children's future. Defendants hatch a fraudulent scheme to transfer title of the KRR property. This is where we start getting into what the other stuff is. On June 27th, 2023, after Kouri's arrested, Katie originally commenced this action against Kouri and KRR. Both prior to and after the commencement of this lawsuit, KRR, Kouri Richins Realty, held title to certain real property located in Summit County, specifically Lot 210 Frontier Cottages subdivision, that. Upon information and belief, that property has a current market value of approximately $550,000. The estate is looking for where you can start to claw back some of this money back into the estate where it belongs. Look, the Defender is gone. The cash out of the accounts is gone. The HELOC, I don't know about yet, but a lot of this money is gone. Upon information and belief, Kouri, Lisa, and Ronald jointly devised a scheme to siphon assets from Kouri Richins Realty to hinder, delay, or defraud the estate's ability to recover them. To that end, Kouri, Lisa, and Ronnie jointly decided to effectuate a sham transaction through Kouri Richins Realty, where Kouri conveyed title of Kouri Richins Realty property to Lisa, the mom. On June 12th, 2023, after arrest, Kouri transferred title of the property to Lisa via a quitclaim deed. They call it the sham deed. Ronnie executed the deed and signed as Kouri Richins Realty authorized representative because Kouri was in jail. So this is the underlying estate, and the transfers of the property are a huge part of this. And I think what they're going after. What else is going on in the estate case? Estate suing Kouri got stayed largely on all claims due to the criminal case. So we are going to see the estate suing Kouri, Kouri suing the estate, and the probate pick back up, with the caveat that Kouri doesn't have a lawyer. In the probate case early on, there was a motion filed by the estate for relief under the Utah Slayer Statute. That is what it's called. The motions were filed for relief under the Slayer Statute. Oppositions were filed to that. The court issued an order back in 2023. Order on motion for preliminary relief under the Slayer Statute from December 7th, 2023. Having considered the parties' briefing and motion, oral argument, and legal authorities, Kouri Richins' objection to the form of this order and the personal representative's reply to the objection, the court orders as follows. Pursuant to Utah Code 75-2-803, the personal representative seeks 1, an injunction precluding Kouri from dissipating property and assets during the prosecution of the criminal charges against her, which are currently pending in Utah. 2, a constructive trust on Kouri's assets. 3, imposition of a trustee's bond. 4, appointment of a receiver to marshal and manage Kouri's property and assets pending a determination on the personal representative's petition. Motion is granted in part, denied in part. What are they asking for, Emily? Money. They want to protect the money. They do not want Kouri to continue to siphon off funds and move money around that might need to go back to the estate, but that hasn't been determined yet. And they don't want Kouri spending all of the money that might need to go back to the estate on her lawyers. They want to pause all of the money from going anywhere. You can see why Kouri's lawyers were kicking and fighting this, right? Because if the only reason Kouri has money to spend is because of the hundreds of thousands of dollars we saw misappropriated from Eric's funds, then no, you want to freeze all of that money, put it somewhere until it can be decided. Because once it's gone, it's fucking gone. So they are asking to freeze the money and stick it somewhere else and hold on to it. So the estate's not going to spend it, but Kouri's not going to spend it. That is a completely reasonable request. Motion is granted in part, denied in part. Let's take a look. The personal representative must satisfy the requirements of Rule 65A of the Utah Rules of Civil Procedure to obtain injunctive relief. Specifically, 65A(e)(1) is satisfied as a matter of law for the reasons set forth in the court's June 12th order in the criminal case, through which the court concluded that there is substantial evidence to support the state of Utah's aggravated murder charge. The aggravated murder counts as a disqualifying homicide. So they've already gotten to step 1. So step 1 is there a disqualifying homicide for the purpose of a Slayer statute? Yes, there is, in this case, enough probable cause that yes, there is a disqualifying homicide. Of course, that would change if the verdict changed. But step 1, done. The court concludes that the personal representative is substantially likely to prevail on the merits of the petition. That's based on the criminal case. The court has said the difficulty of recreating, chasing, and reversing the flow or dissipation of assets that might occur during the criminal case's pretrial period poses an irreparable challenge to the estate. Cannot be repaired. So the judge is going through each section of the statute. The court goes on to say, although injunctive relief is appropriate, the court nonetheless has concerns that an overbroad injunction could be constitutionally infirm. Right, because now you are teetering on, does Kouri have the right to spend her money on attorneys? Or would that be too much? Right? The court hereby enters a preliminary injunction ordering 1, Kouri, 2, her business, 3, any other business entity that Kouri owns and controls, from transferring, changing title, or pledge any asset The court orders that all assets owned, held, or controlled by Kouri and the Kouri entities from the date of Eric Richins' death have been and continue to be held in constructive trust by Kouri and the Kouri entities for the benefit of the estate. That part, that's the part. So anything that she dissipated, like the home, this order ties back to the date of Eric's death prior to the transfer of the home, which might make it easier to unwind. The court goes on to say, to the extent the personal representative believes or asserts that any transfers or distributions of assets, past or future, by Kouri or the Kouri entities were or are, 1, unreasonable or unnecessary to fund Kouri's criminal defense, and 2, otherwise constitute breaches of Kouri's fiduciary duties to the estate, the representative may seek relief from the court. So this allows another vehicle to potentially undo that property transfer. So the court's initial findings under the Slayer Statute put a freeze on Kouri's assets to not be diminished, other than expenses for criminal defense. These civil cases do not count. Kouri cannot try to get into this money to pay civil lawyers to take her case, which is going to make it a huge issue for Kouri now that her lawyers have bounced. So where are we at the end of the day? Well, on March 17th, 2026, the lawyers that were representing Kouri, they withdrew from all of the cases. Today we covered Kouri suing the estate apparently 2 ways, which is a conflict I have not figured out yet, but we're going to figure it out because there were attorney fees awarded in both for a different amount. There are 2 active cases with like the same complaint of Kouri suing the estate, both from June 2023. Then there's the probate case that had the bulk of the attorney fees, over $66,000 in attorney's fees. And then one case, Kouri versus estate, at $8,000, and one case, Kouri versus estate, at $5,000. And then there's estate versus Kouri is the outlier. So we've got 4 civil cases going on. 2 of them initiated by Kouri. One of them is just the probate matter that was kind of initiated by Kouri, but not really. She made it much more complicated, but the probate matter. And then the estate suing Kouri. Kouri has no lawyers on all 4 cases. So Kouri is going to have to figure out if she is going to represent herself pro se in the 2 cases where she's suing, or if she is going to hire new lawyers with what money? From jail or prison when we get there. And then we have the estate suing Kouri and Kouri's mom and brother, which they're not going to let go because they shouldn't. And then the probate of the estate, which we got into a bit, but that case is where the initial Slayer Statute motion was brought that froze or purported to freeze Kouri's assets, except for what she needed for her criminal defense. But that should all be frozen at this point because she has state or county appointed representation. So how and when is Kouri going to hire new attorneys? What is going to happen with these cases now that Kouri has been convicted of Eric Richins' murder? Once she is sentenced, there will then be a final judgment that the civil attorneys can bring forward in these cases. And then I expect we will see a bunch of litigation trying to close out aspects of these cases. What's not going to be closed out entirely is the estate trying to claw money back into the estate from Kouri. The estate is saying that Kouri took funds that should have been for the estate in a variety of ways to a variety of places, and they are trying to pull that all back in, including retirement accounts we've heard about, including money out of a safe, money out of bank accounts, money from Eric Richins' credit cards, plus the HELOC, plus K. Richins Realty transferred a home into Kouri's mom's name, but the property of K. Richins Realty was derived from estate property, so they are trying to claw all that back in and pull it back to the estate because it is estate property. And as I said earlier in stream, when we talk about the estate property, remember what this trust was for. It was for Eric's sons, his 3 kids, who no longer have a father, whose mother has had paternal rights terminated and is going to be in prison for the rest of her life, or at least I think she should be. And if not, she will be in there substantially for the rest of her life. We'll have to wait for sentencing. But this estate that she was dissipating assets from is to benefit her kids. And so the estate is fighting to bring all that money back in. And if the estate has the ability to argue for substitute assets, and if Kouri's mother and brother are getting paid for the photos used by ABC or other media, it's fair for the estate to go after that aggressively, especially if there's reason to believe that that money is going back to Kouri and she's trying to sidestep around any restitution she may owe by having those funds paid to her mom. And we might see the prosecution try to go after that if the statutes in Utah allow it for restitution back to the estate. And then in the financial crimes case, because there's still another criminal case ongoing, in addition to those 4 civil cases, some tax issues and business cases, because Kouri's taken money from businesses that didn't get paid back. We haven't done that today. So when will we see all of this come to a head? After sentencing, which is why we overviewed it today. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.